Good morning, everyone. This is Mitch Frumkin. I'd like to welcome everybody to today's webinar on transition. Just to make sure that you can all hear me as I speak, if somebody wouldn't mind just there's a place on your screen where you can ask a question or chat. If you wouldn't mind just letting us know that you can hear us, I would appreciate it so that, oh, good morning, I can hear. All right, so we're all set. All right, thank you very much. Welcome, everybody. We have a pretty big crowd today for today's webinar, and I really appreciate everybody joining us. As you can see, because you all just jumped right in, as we're speaking, if anybody has any questions, feel free to type them out. They'll show up on our screen, and we'll either recognize them at that point or defer them because it's something that we're going to cover later on. But thank you very much for joining us. As you all know, we have a special guest today joining us. Originally, the presentation is based on the engineering concepts behind transition, and we also have Mohammed from WilkenGuttenplan to share with us his insight in transition from the financial perspective. Most of it, if you don't know him as Mohammed, he's actually the mayor of our industry in New Jersey, so you may know him as the mayor, not as Mohammed. So.
Actually, that's not true. I'm just a has-been past president of CAI New Jersey.
And if anybody has any comments you'd like to make about Mohammed, please feel free to put them up on the screen.
Absolutely.
So let's just see if we're working here. Again, my name is Mitch Frumkin. I'm president of Kipcon, and the first portion of the presentation is going to be regarding the transition, the beginning from the engineer's perspective. Also, as you know, this webinar is given with continuing education units. So in order for us to make sure that you're staying with us the whole presentation, we are able to check to make sure you're online for the entire thing after the presentation is over, but also at some time through the presentation, which we're not going to tell you when, there will be a keyword that we're going to give you that when you want your certificate showing that you have continuing education credits, all you have to do is email Stacy at Kipcon and she'll send you the certificate if you get the password right. So please pay attention. To give you a little bit of my background, other than being the president of Kipcon, I've been very involved with the Community Associations Institute for many years. As you can see on the top here, I've been president of both the New Jersey chapter as well as the Pennsylvania Delaware Valley chapter of CAI. I also served as the president of the National Foundation for Community Association Research, as well as I served as president of the National Institute. When I was serving as president of the National Institute, I happened to be reading an article one day as I was traveling down to Washington for a meeting, and the article was in the National Association of Home Builders magazine, and it talked about construction defects and how it's a big problem for developers that are building community associations across the country. So what I did through CAI is we reached out to the national president of NAHB, and we formed a partnership with those guys pretty much, and we developed what's the best practices paper on transition. And if anybody would like a copy of that best practices paper, you can either go to CAI National's website, caionline.org, or to make it even easier, you can just request a copy of it from us, or if it's possible, we'll thank you for attending the webinar. We'll send everybody a copy of this best practices paper on transition. A little update on that also is that that best practices paper is a number of years old, and right now I'm serving as the chair of a national committee, and we're in the process of updating that best practices paper. As a matter of fact, this afternoon, I have a conference call with somebody from NAHB, National Association of Home Builders, because they're going to be involved with us in updating that paper. One of the things that came out of that paper is CAI offers an advanced level course, the M370, Managing Developing Communities, which is based on, it's about transition, the whole process, and the ultimate goal of both the paper and the course is to share knowledge and best practices so that communities and developers can go through transition in a non-confrontational way, which we'll talk about as part of this presentation. In addition to that, I chaired the committee that developed the National Standards for Reserve Studies, which was just recently updated. And if anybody would like a separate seminar on reserves, Mohammed and I would be more than happy to do that. So that's a little bit of my background. Mohammed will share with you his background when he comes on to speak in a few minutes. And again, if anybody has any questions, please feel free to jump in. The topics that are going to be touched as part of my presentation is transition, what are the key concepts, risks, expectations, and you'll see that expectations is a big thing when it comes to confrontation and a non-confrontational transition, what the expectations are of both the builder as well as the new homeowners. Evaluating claims, the dangers with transition, and certain strategies that are used these days to get through the transition process. So what is transition? Transition is a process. One of the things that is misunderstood by a lot of people is that they think that transition is a point in time when the community goes from developer control to homeowner control. But that is actually known as turnover. It's not transition. Transition is the process that you can see on the right-hand side of the screen. It begins with the document development, which I'll talk about all of these in a little more detail, but it goes from document development all the way through to an independent community. And it's a process that sometimes can last years and it sometimes can last months. But it's a process. It is not a point in time. So why does it occur? Transition process evolved with the development of community associations. Community associations go back to the early 1970s in this country, where at that time there were probably only about 10,000 community associations across the country. And right now there's probably about 250,000 community associations. So it's the purpose is to provide a mechanism for the sponsor or the developer, whatever name you want to use, to turn over the community to the new homeowners as they move in. So transition is something that evolved with community associations, because before community associations you really didn't need transition. It was a different type of model in terms of buying a new home. So that's what transition is and why does it occur. It's a process. The first phase of the process I mentioned before is document development. So in that phase, it's when the developer first decides they're going to build a community association. In order to build a community association and to build it and to create one, and creating one happens even before it's built. So when you create a community association, there are legal documents that are prepared, which include things such as the master deed, the bylaws, the budget, and in addition to that, some of the other documents are the actual design drawings for how to build the community. So phase one is actually document development, where you're actually creating a community association. So a developer will sit down and say, I'm going to build something, and what am I going to build? A community association, and in order to create it, there are documents that are developed to do that. So that's phase one. Phase two is construction. This one is pretty straightforward. So what's construction? It's when you build the community. So that's why when I said a few minutes ago that creation and construction are two different things, because construction is when you're creating the physical buildings, but creation of the community happens by the legal documents. So phase two is the construction. Phase three is turnover. Turnover is the point in time I mentioned before when the community is turned over from the developer to the new homeowners. That's the point in time. It typically occurs when 75% of the units of the homes have been sold. So that's turnover. And the last, phase four, is an independent community, the time when the homeowners have taken control of the community. Now, one of the goals of the developer, or a couple of the goals that a developer has when they build a community association, of course we'd have to say on the top of the list is that they want to make money. They do it to make money. That's why you build homes, to sell, to make money. But the other reason is that some of them buy into is that when you build a community of a few hundred homes and you go through a transition process in a great way, what's going to happen is everybody in that community is going to become a salesperson for that developer and recommend to all their friends when they're buying a new home in a community to buy from that builder. So one of the goals also is to make money as well as to turn everybody that moves into that a happy homeowner and a salesperson for that developer. Some of the key concepts. The first, obviously, and it's not just with transition, but it has to do with anything that has to do with a community association, is what are the common and limited common elements. These are the things that delineate what the association is responsible for versus what the individual homeowners are responsible for. There's two types of common elements: the general common elements, which are for the use of all the owners, and limited common elements, which are for the exclusive use of one or more individual owners, and they're typically replaced and maintained by that association, but in some cases, the limited common elements may be maintained and replaced by the individual homeowner. So it's very important to understand the governing documents to see who's responsible for what. In terms of a transition, why the common and limited common elements are a key factor is that because when you go through transition, that is what you're accepting responsibility for. So when you're dealing with the financial issues, the construction issues, it's only related to these common elements because that's what the association board of directors on behalf of the homeowners have the responsibility and the fiduciary responsibility to take care of and make sure you got the right thing. One of the things that's happened a lot in the last few years, which I've seen, is that developers see that the common elements are what create their risk factors. So what they try to do sometimes is minimize the amount of the common elements, which in essence is actually minimizing their risk. For example, I met with some people. I gave a seminar a few days ago on reserve studies, and we were talking about the fact when it comes to reserves and this, that in some cases, even if you have multifamily attached units, the common elements may be set up in such a way that the roofs are the responsibility of the individual unit owners rather than the association. And the concept behind that from the developer's perspective many times is to reduce their risk going through a transition, because then it's the responsibility of the individual homeowner, not the overall association. So it's something to pay attention to, but it's very, very important in anything you do with associations is to understand what the common elements are and what the limited common elements are and who's responsible for what. When you take a look at the community association industry across this country right now, you'll see that more and more transitions are occurring. It's very big in this part of the country right now. There are a lot of communities that are going through transition. When you look at the total amount of residential homes that are owned in this country, about 24% of them are community associations. But out of all the new homes that are being built, 80% of them are being built as community associations. We're located, as you know, in the Northeast, primarily in New Jersey. In this part of the country, probably close to 100% of the multifamily communities are being built as community associations. So it's a very rapidly growing industry and rapidly growing amount of community associations. So I think I mentioned before, currently in the United States, there's about 340 to 350,000 community associations. When they first started, I guess back in the early 1970s, there were only about 10,000 associations. But you can see by these numbers that the amount of transitions are geometrically expanding because everything is being built as a community association. So in every case, there's a transition from the developer to the new homeowners. The type of association, as I mentioned before, determines the risks because it determines what the common elements are. For example, very basically, in a condominium, the common elements typically make up all the site-related items and the buildings, so those are all the risk areas. In a homeowners association, it's typically just the site, and the buildings with the residential units are the responsibility of the individual owners. If you have a clubhouse, that is also part of the common elements in a homeowners association. And there are more and more mixed-use communities where there's a combination of single-family homes, multifamily homes, commercial portions of the community. So it's very important, again, to understand what the common elements are, what type of ownership, because that's what defines the risks when you're going through transition. Another key concept is reserve study. The reserve study is a budget planning tool which establishes a funding plan to offset future major common area components. Basically, when you have to replace the roof, making sure you have enough money in the bank to do it based on how much you're setting aside each year. There's a few different types of reserve studies that are used. For example, at the development of the governing documents, there's a budget that goes in those documents, and what's in there is what's called a preliminary study, a preliminary reserve study. I have to mention also that recently when the CAI National Reserve Study Standards were updated, this is a new type of study. It was not included in the old one, and a preliminary study essentially means that it's a reserve study that's prepared based on only the drawings because nothing's been built yet. So there's a reserve study prepared for the governing documents called a preliminary study. During turnover, there's a full study done, and that's a whole other seminar. If anybody wants a seminar on reserve studies, we'd be happy to do it, but during turnover, it's a full study based on the as-built community, not based on the drawings. And one of the things I'll touch on in a few minutes is that's one of the risk areas if there's a difference between the two and the study's not updated. And then after turnover, there are reserve studies done on a relatively frequent basis by most associations, which are called updates. But that's after turnover, and that's really not part of the transition process. That's something that communities do on their own to make sure their budgetary reserve requirements are met. Now let's talk about the developer's engineer and what their role and responsibility is. Developers absolutely have engineers that do work for them. What they do is things like design the community, and I would throw into that engineers and architects. So they are the ones who prepare the blueprints that are used to get prices to do the work and actually to build the community. So the developer's engineer would prepare the design. In some cases, from a risk management perspective, a developer will have an engineer review their documents. The documents I talked about a little while ago, because sometimes those documents are prepared before the engineering design is complete, so they may have them review the documents to make sure that it properly describes what the new community is from a risk management perspective. A developer's engineer will prepare the budgetary items such as the reserve study I just mentioned, the preliminary reserve study. In a number of cases, developers will hire an engineer to do quality control inspections during construction to help them make sure things are being built correctly. So they'll have a third party come in to watch things as it's being built. And sometimes the developer will have their engineer do an operating manual. I always compare that to you buy a car, you look in the glove compartment, and there's a manual to how the car runs and how to work the car. But you move into a community association, take over millions and millions of dollars worth of assets, and nobody really gives you a book that tells you how to do it. So there are some developers these days who actually prepare operating manuals by their engineer that is given to the association. Now you have the association's engineer. Keep in mind that typically the association's engineer is not retained until after turnover takes place, because that's when they take control of the community and they have the power to then hire an engineer to prepare, first of all, a transition study. The purpose of the transition study is essentially the same as doing a home inspection for a house, except for an entire community, and it's to review the community to assure that it's built in general conformance with the plans and specs, and that it matches also what it says in the disclosure documents. But I'll talk a little bit more later about what goes into a transition study, but it's to overall assure general conformance with the plans and specifications. Also, the association's engineer will prepare a reserve study. There's two purposes of the reserve study in that case. The first is to prepare a reserve study for the community going forward based on what's actually built, how much been set aside to date, and a reserve study for going forward. The other reason it's done in many instances is to do a comparison to the reserve study prepared by the developer as part of the governing documents to confirm that initial reserve study was adequate. Keep in mind that when you do a reserve study going forward, it's built on what was actually built. When you're doing a comparison to the original study, you have to keep in mind that it's based on just the design drawings, not the as-built community. That's why it's important for the developer, as part of the transition process, to update the reserve study to match the actual as-built community as things happen. A lot of the larger builders know this, and what they do is they have a plan in place where they'll have a preliminary reserve study done as part of the governing documents, but then at the end of construction, they will have it updated to reflect what was actually built. But I'll talk a little bit more about that later on as one of the risk things that come up, and also what does adequacy really mean? For example, the state of New Jersey, the governing statute says that the developer must include in the budget adequate reserves, but there's really no definition there of what adequate means. So I'll touch on that again in a few minutes. What the transition study does, it identifies areas that fall out of compliance with a number of standards. For example, does it match the architectural and engineering plans? Does it match the specifications? Does it match the governing documents? Was it built with good workmanship? And was it built in conformance with the manufacturer's standards? So I'll touch on this a little more in a few minutes, but it's very important that when you have your transition study done, that if it identifies any kind of deficiency in the construction, that it clearly identifies what standard it's not in conformance with. What are some of the standards that I talk about? There's the building code, and keep in mind there's a misunderstanding in many instances that when an engineer does a transition study, they're reviewing the entire design for conformance with the building code. That's not what is typically done. What happens is that if an engineer is doing an inspection of a community, the assumption is made that the design drawings that were prepared by a licensed architect or licensed engineer and reviewed by the local municipality building officials, the design was approved, designed, and built in conformance with the building code. But if we go out and do an inspection and something doesn't match the design drawings, then one of the things is done is to check to make sure that what was built still does meet the building code. So that's a misunderstanding I've seen a lot recently, that people are under the impression sometimes that the engineer will do a complete code review of the original design. That type of thing can be done. It's very expensive to have done, and it's out of the scope typically of somebody doing a transition study. Some of the other standards are the approved design drawings, which I touched upon a second ago, manufacturer's literature. Then there are performance standards. The code tell you minimum ways to build things, but there are also performance standards that say how things should perform. In the state of New Jersey, by statutory requirement, when you buy a new home, you get a warranty. It's the regulations governing new home warranties and builder's registration, which most people know as the HOW warranty. That is a performance standard, and what I mean by that is a very simple example. The house should not leak. So if it's leaking, it's not performing. That doesn't mean that it's not leaking and it's not built right, which is a different thing, but a performance standard says, is it performing the way it should? And one of the main things is it leaking, and it should not be leaking. The other thing is, in terms of a standard when it comes to the reserve study, is the National Reserve Study Standards of the Community Associations Institute. So that's a standard that reserve studies are measured against. Some of the key concepts also are a transition study is a report that identifies conditions, but in a lot of instances they lead to other things and which are not included in the basic report. For example, the cost estimate. If you find a lot of deficiencies, you do a cost estimate to see the cost of them. One of the reasons that you may do that is to see how much damage is there and make a business decision on the cost to fix things versus the cost to litigate. You have to be very careful to make business decisions because litigation costs a lot of money, and I'll give you an example of that in a few minutes. Also, moisture probes. The way to see if water gets behind siding is to do moisture probes. That's something at times evolves out of the study. And in some cases, communities have you do moisture probes as part of the base contract. For example, just yesterday, I was meeting with a potential client in regards to doing a transition study, and they want to include moisture probes as part of the base contract. They don't want it to be an option later on. Same thing with maybe roadway corings to find out the thickness of the roads. Next is remedial designs. If you have to fix something, do a design to how it should be fixed. Meetings and walkthroughs, because generally when you get a study, a transition study, it may include 1 or 2 meetings with the association, but once you give it to the developer, it may result in a number of meetings with the developer, walkthroughs of the community to show them where the deficiencies are, but that's another one of the additional transition study services. When I meet with the community and we give them a proposal for a transition study, I always tell them that that's just the beginning. Sometimes you could double, triple, or 10 times the cost of the initial study, depending on what happens. But if anybody tells you that the cost of going through transition with an engineering report is just the cost of the original report, it is not true. I don't remember any that we've ever done where it stops with the report. There's always additional things that happen depending on what you find and the response of the developer. The other thing I mentioned, invasive testing. You may need to take apart around windows to see why they're leaking, if they're leaking. And last but not least, of course, is litigation or ADR, alternative dispute resolution support, if you do end up in litigation. which is not where you end up, I promise you, but sometimes it just happens. You have to go there. Key concept, another thing to understand, in a community association, you have relationships that you don't have in different types of construction. For example, everything is tied together. Starting in the upper right-hand corner, you have the governing documents is what creates the community and identifies the common elements. Each of the common elements have to be maintained and reserved, which ties back to the budget, which goes back to the governing documents. So it's very important when you get into transition also to understand the relationship between these things, because let's say you find a deficiency with a sidewalk. The answer may not be to replace all the sidewalks, but the answer may be to make a contribution to the reserve fund for a reduced useful life for the sidewalks as opposed to replacing them. So it's very important with associations to understand these relationships. Are there any questions up there? No. Another important concept is what is known as consequential damages. Consequential damages means that if there's damage to one part of the building due to a deficiency in another, there's a much better chance that it's covered under insurance and there's money to fix it. So, for example, you're looking at a picture here that shows in the upper right-hand side that the siding in the building was installed wrong, and because the water was getting through it, it was damaging the work of somebody else, which is the underlying wood sheathing and wood structure of the building. So consequential damages is very important when you get into a situation where you're negotiating with a builder or you're in litigation. The question always comes up, where does the money come from to fix it? And in most cases, it's insurance money, and consequential damages is what triggers insurance money to be available if improper construction of one thing leads to damage of another, which is known as consequential damages. What are some of the risks? Of course, deficient construction or inadequate budget. And one of the problems with community associations as compared to single-family homes is that when you buy a single-family home that is not in a community association, what do? You negotiate the price, and then you do an inspection, and if anything's wrong, you go back and negotiate with the seller to reduce the cost because of things you found wrong. That's the classic way of doing it. One of the reasons why you have more risk in community associations is because you don't do the inspections until after you buy it. So what happens is there's an expectation of perfection. You don't have the ability to negotiate the price based on problems you find, and that's evolved into, in our industry, what I call, and a lot of people call, a culture of confrontation because of this new model, which is kind of backwards from back in the day when people bought homes and they were not in associations. And the risks are high because homeowners' expectations of perfection, a lot of cases lack of education in terms of what transition is, which is one of the things hopefully come out of this type of webinar on what transition is. Poor construction, of course. I mean, people think that developers build things wrong on purpose, but they don't. But poor construction does happen. Poor document development, where the documents that I talked about initially aren't prepared correctly, or the inability of a developer to hire somebody to do inspections of their work. This has become a real problem in the industry because what happens is that if there's a problem that ends up in litigation, everybody who is connected to that project at all gets dragged into the litigation, even if they're only on the site for one day. So what happens if you have a firm that you hire to do third-party inspections, they come out to the site 2 or 3 times, it's then built wrong, then there's a lawsuit against the developer, that inspection firm will be dragged into the litigation. So what's happened is there are more and more engineers that do not want to do work for developers to inspect the work that's being done because of the risks involved with them getting dragged into litigation. Some of the risks, so a couple of examples, starting on the left-hand side, inadequate detailing. This is a situation where there was one little piece of flashing missing, and because of that, the water got into the one beam you see at the bottom that's rotted away, and that beam was supporting the second floor of about 100 units, and because there was one piece of flashing left out that would have cost maybe $100 throughout the entire site, this had turned into $1 million litigation in order to replace every one of these beams. Second one, as-built construction does not match the design drawings. In this case, if you look below, that's a catch basin that should go in a road adjacent to a curb, and it was installed in the middle of a field. Third one is as-built construction, again, doesn't match the design drawings. In this case, you look above and you'll see a retaining wall running along the back of these homes. This was, just goes to prove that no good deed goes unpunished, because this retaining wall was not shown on the design drawings. The developer installed it so there'd be more room in the backyard for the kids to play, because before this was a pretty steep slope into the woods behind it. So the problems this led into is now there's a safety issue with kids falling off the wall. Also, the problem is that because it wasn't on the design drawings, that retaining wall was never included in the reserve study, and it relates to budgetary issues also. Next one is unclear detailing of critical areas. Very, very common also. If you look at that building below, what happens is there's an upper roof that goes into a gutter that drops all the water from the upper roof onto the lower roof, that goes through a downspout that's not big enough because it's taking all that water. And on top of that, if you look at the bottom, it dumps all the water right on the sidewalk in front of the entrance to the home, where in the winter it freezes, creates an icing hazard, and it's because the drawings did not show where the gutters and downspouts should go. A few more examples. Left-hand side, poor workmanship. This is looking into a catch basin where the water should be going into the catch basin through the pipe opening that you see there, but instead it's coming through the wall itself because the wall wasn't built right. Next one, improperly installed flashing. Again, this is something, consequential damage, where the flashing wasn't installed right, the water gets through when it rains and is rotting out the building. Next one is an example, not following the plans. This plan, very, very common, where the intersection of two materials come together, there should be a flexible joint. It was not put in, so it expanded and contracted, created a crack, and water got in there, rotted out the building. And the last one is lack of coordination between architectural and engineering drawings. The architect draws the plans for the buildings, the engineer draws the plans for the site, and in this case, the buildings are relatively close together. The buildings weren't set high enough, so when it rains and the water goes between them, it sits there because there's not enough slope for it to drain out. In this case, the settlement was that the developer paid to put an underground pipe in between the buildings that then connected to the downspout so the water wouldn't sit in between the buildings. Couple more. Top one, roofing issues. One of the problems with roofs and inspecting roofs is that you have to walk on the roofs in order to see the deficiencies very clearly. One technology that's come out in the last couple of years, which you can see from this picture, is where you do drone inspections of the roof, where you take pictures and you can zoom in and see the roofs in great detail, and it's something that you couldn't do before by just walking the roofs. And it's also much less expensive. So most transition studies these days are done when you're inspecting roofs, where you do a drone inspection of the roofs, where you come back and take a look at the pictures and close-ups. The middle one is use of hard-to-install materials. Again, I think this is a repeat of another picture, where it's a material that's very hard to install correctly, and a lot of times the builder's representative or even the contractors have trouble installing it. They don't understand how to install it, and it gets installed wrong. And then the last one, which is a question mark where there's really no answer to, just on individual cases, is how much invasive testing do you do? If you look at the bottom picture, you'll see water coming in through the deck above and damaging the sheathing above the downstairs sliding glass doors. So this happened in one location. There's 500 units. The question is, how many of them do you open up to find out how much damage there is, which I don't have the answer for the question because it's on an individual basis for each community. Now let's talk about the budgetary concerns and inadequate reserves. First of all, I want to mention, what does inadequate mean? And just in the last year or so, CAI National, the group of reserve providers across the country that I'm involved in, came out with a definition of adequacy. Adequacy means that making sure that the budget does not go into a deficit over the cash flow projection period, which typically in this part of the country is about 30 years. So if you do a cash flow projection of a reserve study going out 30 years, if it drops below zero and you go into deficit, that's considered to be inadequate. If it stays above zero and you always have money during that period to do your replacements, then it is an adequate reserve study. That's a whole other seminar which deals with the different types of reserve studies and funding plans, full funding, threshold funding, and baseline funding. But that's the general concept these days on a national basis in terms of what adequacy of reserves means. But why do you run into problems with the original reserve study, the preliminary reserve studies? Now, sometimes the quantities in the field don't match the drawings. I touched on how at the end of construction, you should take a look at the community to make sure it matches what the drawings show. Maintenance is not adequately funded. A little different off track there, but a lot of times that maintenance is not included, although reserve studies are, so the budget for the common elements may not be budgeted properly because there's not enough maintenance money. The unit costs are developer costs. Let's say you're putting in a cost for a reserve study for sidewalks. The developer costs them $3 or $4 a square foot. The association costs $10 a square foot, and that's what should be in the reserve study. The main difference is the developer cost is based on putting in sidewalks. The association's cost is based on putting in sidewalks and taking out the old one, so it can work. They double the cost. The reserve study, the preliminary reserve study is prepared prior to completion of design drawings. If you do that, then there's very little chance that it's going to match the design drawings, so it needs to be updated. But that's one of the problems. Sometimes in order to get their community approved, they will have a reserve study done before the drawings are completed and then not updated after the drawings are done or after construction is done. Again, as-built construction does not match the drawings. I mentioned that before. POS reserve study prepared by an unqualified firm. That happens a fair amount of times. And then lack of definition of adequate, which I just touched on. What are the expectations? The perfect expectations is that the study will show no construction deficiencies and no budgetary deficiencies. That generally doesn't happen. It's very important for you as managers. I think the majority of our audience is managers. There are some homeowners, but you really need to set the expectations because, as I mentioned before, the most common cause of problems to resolving claims amicably is unrealistic expectations, such as, keep in mind, there's no such thing as perfect construction. The developer did not build it wrong on purpose. I've never met a builder that builds something wrong on purpose. Also, the process is guided in a non-confrontational way. It will most likely stay non-confrontational, which means don't take it personal. It's a business. It's a business. And it's not uncommon for minor deficiencies to exist. And when problems do exist, they should be reported objectively to increase the likelihood that an agreement will be reached. And that's very important. I just listened to a seminar the other day by somebody else talking about transition, and they said that what they like to do is build up all the claims so there's a high point to negotiate down from. That is the wrong way to do it. If there's a problem, identify it, identify what it is, where it is, and what the standard is, but do not try to increase the amount of the damages and the claim in order to increase or to set a higher level for your negotiating perspective. So setting expectations that it should be reported objectively is very important. Evaluating the claims. Typical way claims are resolved is correction of the problems where the developer will come back and fix it. But I hear many times an association will say, I don't want them coming back to fix it because they built it wrong the first time. That's not always the right answer because as soon as you take a cash contribution, which is number two, and then you fix it, if there's anything wrong, you're responsible for it and the developer's off the hook. If the developer comes in and fixes it, they always try and fix it right, but then if they fix it wrong again, depending on your transition settlement agreement, then they may be responsible to fix it again. But as soon as you accept cash and you fix it, then you as the association own it. The other thing I've seen, which I think is a big problem, and I see it consistently, is that associations will win money as part of litigation because of construction defects and then not fix it. They take the money and put it in the bank. That money is intended to fix the deficiencies, not to put in the bank. The last one is contribution to reserve funds, which I mentioned before. Rather than replacement, maybe make contributions to the reserve fund so that for reduced useful lives. Claim evaluation, the transition study should include a list of all deficiencies. And if you have a list of all the deficiencies and the performance standard, then it's pretty easy for the developer to respond and say, agree and will correct, do not agree in the reason, couldn't find it, or that it's an equivalent thing. It may be a different type of windows, but it's equivalent. I don't have time. All right. So it should include a list of all deficiencies, and everyone should list what the standard is. So, for example, design drawing, code, manufacturer's detail, performance standard, which I touched on before. There are different types of claims, strong claims and weak claims. Strong claim could be a deviation from the design drawing if it's not equivalent, a deviation from code, a safety issue, or it results in water or other damage. Now, when I say results in water or other damage, I'm talking that if water's leaking into a building, if water's getting into a building, it's going from the outside to the inside, and it's touching everything in between. So it could be rotting out the structure. So these are very strong claims. Weak claim is if you use a different window, but this window that's being used is an equivalent window or even a better window, then it may not match the design drawings, but you're getting the same thing. The other thing is minor drainage, even if it exceeds the standard. For example, the basic standard for drainage is that after it rains, water should drain away from around the home within 24 hours. But let's say it's 25 hours later and there's a little puddle standing there. The question is, even though it exceeds the standard, what is the damage? And in my experience, that has been a very weak claim, even if it does exceed the standard. So you really have to evaluate the claims in the transition study to see which ones are the strong ones, which ones are the weak ones, prioritize them to make decisions on what you're going to do next. Claim evaluation, then you do a cost estimate. My suggestion is you don't prepare a cost estimate until the response from the developer is received. One of the things a cost estimate does is it builds up expectations that the developer is going to write a big check to the association when the developer may say, I'll fix it, or as part of negotiations, because some of the things are weak claims, like I talked about before, the community may accept a certain settlement based on certain things and not other things. The time for a cost estimate to me is if a developer comes back and says, I'm not doing anything, and it becomes a problem, to do a cost estimate in order to make a business decision. Do we want to sue, or do we want to save the hundreds of thousands of dollars of suing in order to fix the $10,000 worth of defects? Cost estimate, by not doing it until later, avoids setting unrealistic expectations. And again, making a business decision is very important, and not to take it personal. And when I say not to take it personal, I'm not talking about just the homeowners. I've seen in some cases a developer will take it personal and say, I'm not going to fix this even though it cost me $100. I'd rather fight it, and because they feel like they built a beautiful community. When the litigation occurs, be prepared for cost estimates, invasive testing, expert reports, photographs, all kinds of additional work has to be done. And the engineering fee for preparing for litigation and going through litigation, forgetting about the attorneys or anybody else, is very, very expensive. The transition team members typically consists of the sponsor, the property manager, the attorney, the accountant, and the engineer. A lot of times the sponsor or the developer is not involved in that, and the community has their manager, their attorney, their accountant, and the engineer as their team. It's typical that the attorney is kind of the quarterback of the team, but these are the people that are involved. And Mohammed will talk in a few minutes about the accountant's role as part of this team. Some of the dangers. This is a real-life situation that we are involved in over the last couple of years. An association, we did a transition study, we did everything we needed to do, and it found out there's $9 million worth of construction damage, and that was what the defect claimed. The association filed a lawsuit against the developer. The developer then retains legal counsel and an expert. The expert report agrees with the claim, but not the cost of repairing it. This is not uncommon, that a developer will say, we agree that it's a problem, but your cost estimate is much too high. The developer then brings in all 25 subcontractors who built the community and saying they built it wrong. The developer and all the subcontractors report the claim to the insurance company. Each subcontractor then retains an attorney on behalf of the subcontractor, and each subcontractor also, through their insurance company, retains an expert to defend their part of the case. The association pays $1.5 million in legal expense, $1.5 million in engineering expense. So the association's total expense to get up to, and actually I think in this case was through litigation, was $3 million for a $9 million claim. The developer's costs were, their expert was $500,000, their legal expense was $1 million, the third party expenses based on 50 days of depositions with 25 attorneys sitting in a room, and the attorney's making $400 an hour times 8 hours a day, comes to about $4 million, and this is not an exaggeration. I've been deposed when there are 25 people sitting in the room. The total defense cost to developers $5.5 million. So what do you end up with? The association's cost is $3.5 million. The developers' cost is $5.5 million. The total is not $8.5 million. It's $9 million. I'm just an engineer. It's added up wrong.
Yeah.
Mohammed, is that right?
No.
Look at the account. So it's $9 million, and the claim amount is $9 million. So you're spending about the same amount of money to get to a settlement than the cost of repairing everything. So all I'll say with that is be very careful, and there also has got to be a better way. So think about ADR, alternative dispute resolution, mediation, but this is a real-life case of the type of thing that happens. Some of the strategies. For the association, negotiation, mediation, absolutely. Third-party review of reports. I don't see this a lot, but I've seen it once in a while because there is no question in our industry that there are litigious engineering firms that do reports that identify things that identify more than they need to report and come up with a large claim amount. If you have a large claim amount and you're thinking about going into litigation, one of the things you may want to consider is having a third-party review be done of the engineer's report for confirmation of the claims. Sounds kind of weird. I've seen it done once or twice, primarily in big claim amounts. Education the community of what transition is, what transition is. For example, generally when we do a transition study, we attend an open meeting in the community to explain to everybody what transition is, what the process is, and what the difference is between a common element and something that they are responsible for. Next is evaluation of all the claims for strength. I talked about that. Establish a team of professionals with a goal of collaboration. First of all, if you hire an engineer or an attorney and they've done 100 transitions and everyone has been involved in litigation against a developer, I think you may want to reconsider what you do. And the other thing is make sure every one of the people you hire as your transition team understands transition. You don't want to be the learning curve. And this is a science, but there's a lot of art behind it in terms of strategies and things like that. So make sure you put together a good team. And establish a community transition committee of rational people. I hate to say this, but homeowners expect perfection, and a lot of times the people on the boards are the ones that have had problems, and you really need to have a transition committee of rational people, business objective, and not taking it personal because the developer did not return a phone call. It's very important. From the developer side, again, negotiation, mediation. I will tell you, a number of the larger developers try very hard to make sure everything is built right and there's no problems. Expert preparation of budgets, reserves for the public offering statement, third-party inspections during construction, education of the board. Sometimes the developer will provide education to the board about what transition is. Maintain communication. This is from both sides. You have to continue talking to each other. And in some case, encourage a team of professionals with a goal of collaboration. There's one developer in particular I can think of that encourages the association to hire an engineer and gives a list of which engineers that if they hire them, they will pay for them because they know that their reports are objective. Don't be afraid just because you think that all of a sudden has become the developer's engineer. So be very wary of that because sometimes they will pay for it. When you request a transition study from an engineer, a lot of times somebody will call us up and say, we need you to provide us a proposal for a transition study, but they don't identify what they want in it. And there's only one or two management companies I can think of that actually prepare an RFP to solicit a transition study for an engineer. I will tell you, if anybody is going out to bid on transition study and you would like a generic RFP to use to know what to ask for your transition study, just ask us. We'd be happy to provide it to you as long as you let us bid on the study. All right, the study should include what the locations, what the standard is, what it's a deviation for, and the locations. If you say that there's a leaking of the building and you don't say how many different locations it's occurring in, then the developer's not going to be able to make a decision on what to do because they won't know the extent of the damage. So it should include the locations, the problem, and the standard, and I've gone over a few times already what the different standards are. Again, very important, manage expectations. I'm going to say it again, even though I said it before. There's no such thing as perfect construction. The developer did not build it wrong on purpose. If the process is guided in a non-confrontational way, it will most likely stay non-confrontational. Remember, it's not uncommon for minor deficiencies to exist, but I will also say there are some situations where there are major deficiencies, so it does happen. Litigation costs a lot of money, and look at the cost using a business sense, no emotions. How much is it going to cost to litigate versus how much is it going to cost to fix it? These are some references that are put out by CAI. There's a best practices paper on transition, which I mentioned before. There's a book on reserve funds. There's National Reserve Study Standards. If anybody would like copies of any of these, just please feel free to ask us. We'd be more than happy to send it. And now, thank you. If you have any questions, nobody has asked one question, so I guess I hit on everything, or you're waiting for Mohammed to answer all the questions. So now, I thank you. I'm going to transfer it over to Mohammed. And the key word for today, when you're sending us a request for continuing education, is rainy day. So
it's going to be the time.
So all you have to do is send an email to Stacy and say, I'd like a continuing education certificate, and today was a rainy day.
All right. Thanks, Mitch. So now that Mitch has bored you all to sleep with all that technical information,
now you've got an accountant to talk.
Yeah, now you get me to finally talk, and let's talk about what's really important here, and that's the money part of it. All right? So we're going to talk about transition and some financial and non-financial aspects of a transition for community associations. So really speaking, when does transition start? Transition does not start when an association reaches 75% of unit owner ownership, and now the board is trying to take over from the developer. Transition actually starts right in the beginning, when the developer is developing the project here, because you have to keep the end in mind, and that's what the developer does too. The developer keeps the end in mind, knows that eventually he's going to turn this over, he or she is going to turn this over, he's going to have the board run the association, and of course wants to make money. As Mitch mentioned earlier, that's the whole point. If developers don't make money, then they're not going to do this, and they're not going to build homes. So that's what the whole process is about. And there's a lot of interest groups involved in transition. Of course, there's the developers, there's the unit owners, there are the current unit owners, the future unit owners, and this relates to people's homes. So no matter how much we try and say, let's not take this personal, sometimes it does become personal. So there are steps that we can take to try and make it as less personal and as less contentious as possible, and we're going to talk about those moving forward. So for our agenda here, we have typical financial claims that we'll talk about during the transition process. We'll also talk about best practices at inception, because as I say, transition doesn't start at the end when you're at 75%, it starts right in the beginning. We will talk about the period of developer control, what are the best things to do while it's under developer control. We will talk about managing finances during that period. Then we will discuss benefits derived and deficit funding, the difference between the two. And then we'll talk about a little bit about the expectations of the transition process itself. So these are the typical financial claims. Now, before we get into that, let me tell you, us as accountants, what it is that we really do. There are two things that we can do for an association at transition. We do what's known as an agreed upon procedures report, or we do a consulting report. Now, a lot of people will come to us and tell us that, can you do a transition audit? It's not an audit, because an audit requires us to give an opinion, and we're not giving an opinion here. So the two reports that we do, what are the differences between the two? Agreed upon procedures report lists out certain procedures that with the attorney, the association will tell us to do, certain calculations that we will do, and we will prepare a report and say, based on those calculations, this is the amount that is to be claimed from the developer. It is a factual report. It does not entertain any expectations, or it doesn't talk about we believe, or our thinking is, or this is what we think you should get. It says this, it just states these are the facts, and based on the facts, this is the calculation. And so for an agreed upon procedures report is usually done when the accountant is the auditor of the association, or has been the auditor, or will be the auditor going forward. So that's what we would do if we were already involved with the association. The consulting report, now that's totally different. That is from an expert witness point of view. A consulting report can include anything, can include facts, and can include expectations, and we would then be an expert witness for the association. Now, what are the typical claims that can be filed during transition? Inadequate POS budget, estimates too low or missing items and services. These two go hand in hand, and we'll talk about these a little further. Benefits derived shortfall. You calculated the benefits derived during the time that the developer was controlling the association, and the money was not enough. Deficit funding. The developer, while in control, did not fund operating deficits and left the association in the red. Proof of income and working capital, that when units within the association were being sold, maintenance fees was not being collected from them correctly, or the developer did not give management the information in time so that those units could be billed. Working capital, who can utilize working capital and for what, whether the developer is allowed to utilize it or not during the time that the developer is in control. Expenses incurred by the developer that were flowing through the association's books, and the developer was not paying for them. Inadequate replacement funding reserves. Now, of course, Mitch talked a lot about that, but we'll talk about certain aspects of that. Construction defects, I'm not going to go into that because that, of course, Mitch covered. And undelivered expectations. Of course, when a unit owner is looking to buy a unit in an association that's being built, you go to the website and it promises you the world, and then what you get sometimes may not be what you were promised by the developer. So all these are certain claims that will be covered during the time that we're going through transition. So developer best practices at inception. So a team approach. You have the developer there, you have the engineer there, you have the accountant there, you have the management company there, and of course the unit owners. It's all about if from the beginning you work at it as we're all part of a team, the whole process, we are all in it to get to the point where we want this association to strive once the developer is done, and keep it the lines of communication as open as possible would definitely make transition a much easier process. And the other thing is, and I'm sure that there's mostly managers who are listening in, if you can have input at the time from inception, and you can guide the developer. A lot of the developers out there, of course, have been doing this for many years. They do this. They do associations all the time. But you will have developers out there that are not familiar with associations. I've worked with developers many times who are doing this for the first time. And as a manager, you can absolutely guide them and give them input from the beginning so that it would make transition a much easier process at the end. And so then also define and disclose as much as possible. Lines of communication are so important. Open lines of communication. Make sure that things are as transparent as possible right from the beginning. And make sure that the unit owners who are coming in understand the levels of services that are being offered, and what will be given and what will not be given. And if they are asking for things that are beyond what is offered, then of course that's going to cost them more money, and that will increase their maintenance fees. Also, preparing an adequate budget. I'll tell you, I have seen associations where the budgets that were prepared at the time that was included in the POS some of them were ridiculous. I saw one where it was a large community with several mid-size buildings, and the budget only included one elevator, which is absolutely ridiculous, and that's of course a claim waiting to happen at the end. Another thing is that when you're having a budget prepared, especially if it is a budget relating to a high-rise or a mid-rise building, you have to have utility studies done, because you need to know for budget purposes how much it's going to cost for water and sewer, for electricity, for gas. So often I have seen those numbers that are inadequate in the beginning, because of course the developer underestimates them. The developers walking a fine line between having an adequate budget, but also making sure that the maintenance fees is low enough that it's attractive to future unit owners. So you, as the manager, you have to make sure that you're involved in that process and you're helping them to have an adequate budget, so that later on it doesn't cause a problem during transition. Then deficit funding. Define whether you're going to be doing deficit funding or you're going to be doing benefits derived, and what's the formula for that. And make sure that formula, whatever it is, you are following that formula and applying it consistently. And then you have to understand what will be assessed and how it's going to be used. As I mentioned earlier, working capital. What do the governing documents say? Who's allowed to use working capital? When can it be utilized? Very often, developers will not be allowed to use working capital to offset deficits. So you need to make sure that you're aware of what's in your governing documents. And then one of the things that Mitch did mention is updating the reserve study during the time of development. You also need to update the budget, because very often the budget that's prepared at the beginning may not be adequate, and you find that out when the association is being built. For example, especially within high-rise buildings, I've seen so often that the expectation of maintaining the HVAC units costs a lot more than what was expected at the beginning. And so once you see that that's happening, you need to make sure that the budget is being updated on a regular basis. So during the developer control, now there are certain legal aspects, laws that are out there that help you. There is what's known as the Planned Real Estate Full Disclosure Act, and there are certain requirements during the developer control. One of them is that the association needs to have an audit done on an annual basis, that it needs to be distributed to all the unit owners. They need to have the financial statements in time. Payments of benefits derived. It talks about operating expenses and calculating the benefits derived. It doesn't give you how the calculation should be done. It just tells you that there needs to be a calculation that's done. It talks about the replacement funding and having the developer pay in and the unit owners pay into the replacement fund, so there are adequate funds in there as and when they are needed. It also talks about adequate budgets, which we just mentioned, and the fact that a budget has to be prepared and it needs to be included in the governing documents. Now, you also have the Department of Community Affairs. It talks about, and the Department of Community Affairs is involved in an association while it is under the developer control, and also they also require that an audit be done within the first 90 days and be distributed and be finalized and distributed to all the unit owners. The DCA absolutely does not look favorably at associations that have operating deficits in the audited financial statements. And as most of you, I'm sure, do know, that there are fines that the DCA will levy on the developer during the time that they are in control if they are not in compliance with completing the audits or funding the deficits. Then there's also the role of the board and the finance committee during the time that it's under developer control. The PREFTA does cover that as well. And then the role of the professionals, as I mentioned, the accountant does the audit during the time of developer control, makes sure that the budgets are adequate. You have your engineer updating the study. You have the attorney who's there, who's working with the association, working on collections if there are receivables out that are due to the association or during transition as well. And then you have other professionals that you're working with as well. So we're going to talk a little bit about subsidy funding during the cash flow. One of the biggest issues with subsidy funding is timing, because what happens is that you prepare financial statements, you prepare the monthly financial reports for the association, and in there you note that the association has a deficit. Then that financial report goes to the developer, and the developer then pays in money for funding the deficit. But the thing is that there's a time lag between by the time the expense has been incurred and it goes to the developer cuts the check and gives it back to the association, and in the meantime you may have cash flow problems. So there you have to understand that there is a time lag. And we also find sometimes we'll deal with associations where the developer will not fund any money until after the audit is completed. And that really creates a problem for an association, because they don't have the money to pay their bills. They're dipping into their reserves, they're dipping into their working capital, and of course then by doing that, they're not earning investment income on there. So there needs to be a plan as to how the deficit, how the subsidy funding is going to be calculated when it's done. One of the examples that you can use is to know an estimate amount and have the developer pay in the money during the course of the year, and then true it up at the end of the year when the audit is done. All expenses need to flow through the association when you're paying for deficits or you're paying for subsidies, because it gives a realistic expense. It gives you a realistic financial statement, so you know whether your budget is adequate or not. If you have a developer that's paying for certain things off the books, it's not going to give you a realistic picture. You won't know what you need to pay for. I will tell you, for example, I saw an association where the developer pays for insurance, and the budget was prepared several years ago, and then when the association had to go out and get insurance, it was a real wake-up call for them, because now they found out that the insurance cost a lot more than what the budget had in it, and now they had to go back to the unit owners and increase the maintenance fees all at once at the end, and it was not a good situation. So there are certain techniques that you can use for cash flow management. As I mentioned, you have the developer pay you in advance or pay you throughout the year so that you have enough cash flow. Sometimes developers will give loans to the association, and that will be then adjusted at the end of the year depending on what the deficit actually is, and whether there was overfunding, then that's owed back to the developer. Working capital, sometimes associations will utilize working capital, and sometimes the public offering statement actually does allow developer to use that, or if not, then they'll use it, and then the developer will give the money back to the association at the end of the year. One thing that you do not want to do, and I see that happening all the time, is you do not want to compromise reserve and deferred maintenance funding, because playing catch up at the end then is really difficult. Usually the money then gets used up in other areas, and then you have a situation where the reserves are just not adequately funded. So you need to make sure that whatever happens, you put money aside in the reserves, you follow what the study says, or whatever your calculations are during developer control. So now we'll talk about benefits derived. So is benefits derived an art, or is it a science? Benefits derived is actually an art. It's not a science. If you have a room full of accountants and you ask each one of them, how do you calculate benefits derived, they'll each tell you a different story and how they're calculating it. So this is this comes from PREFTA, from the Planned Real Estate Full Disclosure Act, and it talks about benefits derived, and it says, until such time as the association shall make an assessment for common expenses, the developer shall pay all of the expenses of the common elements and facilities. So until the first unit is sold, the developer is responsible for all expenses. Once the first unit is sold, then the developer can start handing over some of the expenses to the unit owners. It also says when the association has made a common expense assessment, the assessment shall be assessed against the units individually owned and under development in proportion to the benefit derived by the unit from the item included in the budget. So what is the benefit derived? If you have a unit that's not developed, that's not sold, there are certain benefits that it is getting. For example, if the snow is being cleared, if the lawn is being mowed, if there is a clubhouse and the clubhouse is up and running, you have your pool that is running, you have people meeting in the clubhouse and the clubhouse being cleaned, the utilities are being paid for. As a developer who is trying to sell units within the association, there is a benefit that that developer is getting. Who wants to buy a unit in an association where, of course, the snow is not cleared, where the lawn is not mowed, where the pool doesn't have sparkling blue water in it? You don't want to buy into it. So the developer is getting a benefit from that, and the developer has to pay for it. So that's what benefits derived really is. Going on, continuing in PREFTA, it also talks about the association shall, prior to making an annual assessment, prepare and adapt an operating budget which shall provide for any and all common expenses and be incurred during the year, as well as adequate reserves for repair and replacement of the common elements and facilities. So it specifically talks about reserves, making sure that the reserves are adequate and that money is being put aside in there and that everybody is paying for their proportionate share. So as I said, the developer is getting a benefit of the clubhouse being run, but the developer is also supposed to pay for those units that are not sold their share of that clubhouse. So for example, if you have an association that has 100 units, it has a clubhouse, the clubhouse is built, there is a roof over that clubhouse. Even you as if there's a unit owner who's moved into the association, they're paying their share of funding that roof. But the developer has to pay the share of funding that roof for the units that are not sold, because the clock on the roof is ticking. It doesn't matter whether one unit is sold or 100 units are sold. That roof is going to have to be replaced when it needs to be replaced. So the developer has to pay the monies for those unsold units for that roof. There are certain claims, of course, that for benefits derived, as I said earlier, it's an art, it's not a science. It's easy a source of claims because there's no real methodology. As I said earlier, you can have a room full of accountants and each one of them will have a different aspect on how it is calculated, and the unrealistic claims can be very costly to the association. I've heard the term of throw everything at the developer and let's see what sticks, but that's really not a good approach, because there's time and energy that's involved, there's costs that are involved in preparing these reports and going through a transition claim that's unrealistic. It affects your credibility as an association. There are certain legal aspects. If you are filing a benefits derived claim and the claim is not realistic, you could actually end up having the developer suing you because the claims were not realistic. The accountant has to be able to justify what's in there, what's in that claim, and having a claim that's unrealistic can be a problem when actually you get to court and having the accountant on the stand and having to justify what they have there. I'm sure Mitch can actually vouch for this. Unrealistic claims can be costly on an engineering side as well, especially relating to useful lives and the costs of replacing the items. If you pad them and you go to court, of course, it's going to be a problem on justifying those costs. So, ongoing association operations and benefits derived, items that are in the budget for which unsold units have to pay. There are what's known as, within the operating budget, you have fixed costs and you have variable costs. Fixed costs are costs that are incurred. Does not matter whether there's 1 unit sold or there are 100 units sold. Those are costs that you're going to incur anyway. And there are variable costs that increase as more and more more and more units are sold within the association. Then there are the replacement fund costs. There are fixed costs there, as I talked about. The roof itself, that's a fixed cost. It doesn't matter how many units you have sold, but you got to fund for that roof. Then there are variable costs. There are certain items, like for example, you could have sidewalks that are put in as and when more and more homes are being sold. So that's a variable cost, and that gets added on as more homes are being sold. The DCA is actually currently working with CAI and the builders group on coming up with certain expectations for benefits derived. I know they're working on that, and hopefully we can have something that will make it more uniform as to what's supposed to be included and what the developers need to be paying ongoing while the association is being built. So let's talk a little bit about fixed and variable costs for the association. Now, if you have a gated community, you have security at the gate, doesn't matter how many units are sold, you're going to need to pay for that security. There's certain insurance expenses that you will incur. Of course, if you have an association that has different buildings, as more and more buildings come on board, you will add on to the insurance, but the general insurance will need to be paid from day one. So it doesn't matter how many units you have. The amenities that you have within the clubhouse, the pool, the bocce court, the spa, whatever you have. If you have an adult community that may have an activities director, again, it doesn't matter how many units you have sold, that activity director's salary has to be paid. Then, on the other hand, you have variable expenses, landscaping. As more units are sold, as more lots are sold, landscaping of those lots will get added on and will come on board, and as more of them are sold. Snow clearing, certain roads will be cleared, certain roads will not be cleared depending on whether there are homes that are there that are sold or not. Again, certain utility expenses, depends on what type of buildings you have. If you have a lot of different mid-sized buildings, these actually could be partly variable and partly fixed, depending on whether you have, once one unit is sold within a building, you need to heat that building, and so you have certain fixed costs within there. But if you are paying for utilities within the units itself, then those are variable, and those will not be paid until the unit is sold as well. Management fees, you have a certain fixed aspect, proportion to that, but then you also have a variable cost that for each unit that's sold, management fees keeps increasing. You also have, on the replacement side, as we talked about, the clubhouse itself, doesn't matter how many units are sold, the entrance road, although roads could be a different item, because a lot of times the developer will say that they will not top coat the road until all the units are sold, because of course they have construction vehicles that are coming and going, and they do not want to pay for the repair of that road. But once a road is top coated, then it has to be included in the funding, in the replacement fund. Guard houses, if you have the security, you have the guard house there. Once that's built, it's built. It needs to be included. Individual unit building components, those could be variable as more and more buildings come on board. Again, here it says the roads, especially as I mentioned, if the top coat is not done, sidewalks as more units are sold. If you have single family homes and the sidewalks are being built as more homes are being built. Now, if of course you have a high-rise building, then a lot more costs are included in there as fixed because the whole shell is already built and they need to be funded as soon as the first CO is issued. So, what are the realistic expectations of the transition process? As I said, you begin with the end in mind. Keep the process open, keep the lines of communication open. The developers there to make money, the unit owners are there to make sure that they are getting an association that is financially sound, that is built well, and that they have enough money in their reserves to replace the common elements as and when needed. And then costs and benefits of procedures and use of experts. Make sure that you have the experts. There are people out there who do this. Make sure that the board understands that they're not experts in this process. They need to utilize experts that know what they're talking about. The implications of subsidy funding, understand the approach of your professionals and the other side. The more you know what the other side is saying, the easier the transition process will be. The team has to have a captain. There has to be somebody in the transition process who is the go-to person to whom everybody reports and who deals with the experts, who deals with the outside parties, and it just makes the whole transition process a lot smoother. Identify issues early and make sure that you resolve them as soon as possible. If the budget is not adequate, update it as soon as possible. If reserves are not being funded adequately, have the study updated and make sure you're funding that. If there are construction defects, make sure that try and make sure that those repairs are done as soon as possible so that transition is as smooth and as painless as possible when it really does happen. All right, as Mitch mentioned, we use CAI to provide us a lot of resources, and you can always come to us. Now, I believe we're turning over to the questions.
Yeah, we have a couple of questions. I think this is Mitch back. There's one for me and one for Mohammed. So let me go to the one that's for me. We're going to scroll up a little to get to it, and I appreciate everybody staying with us. Let's see. How soon after the last settlement should the transition study be completed? Is there a deadline to submit a transition study? Generally, it's accepted that the transition study is something that the association starts looking at having done as soon as 75% control has taken place and the board is in charge, so they can actually hire an engineer and an accountant. In some very rare instances, the developer promotes having a transition study done even before 75%, but it's very, very rare. There's no statutory requirements in terms of when it should be done, but the reason I say it should be done as soon as possible is because sometimes deficiencies have turned into maintenance problems, and there's a gray area where a deficiency is a deficiency and a maintenance item is a maintenance item. So you need to make sure that you separate the two. I will say also, though, a little asterisk on that, is that sometimes if a problem becomes a problem because of a lack of maintenance, it may be the developer's responsibility because they were responsible for maintenance. So there's all kinds of interrelationships here, but it's typically suggested that you do the study as soon as possible. Even if you have, I was somewhere the other day where they have a phased community, where part of it isn't built yet and it's not going to be built for a while, then I still suggest that the study be done as soon as possible of what has been constructed, because, for example, when I talk about performance warranties, some of those warranties only last a year or so, and deficiencies have a tendency to get worse. and problems get worse if they're not corrected. For example, I was at a community yesterday, they've had leaking problems in their buildings for a number of years. They haven't done anything about it. They're starting to go through transition. They didn't have a study done sooner, and the question is, well, maybe the problem is maybe it got worse because you didn't do anything about it, and if we would have known about it sooner, we would have corrected it. So as soon as possible, the better. And if I don't get the answer to if I don't get the question exactly right, please feel free to email us and we'll reach out to you individually. And now there's a question from Mohammed.
Yeah. So the question is, if you take over a site that never had an adequate budget to begin with, how do you get the residents to understand that they need to increase the maintenance fees? So, of course, a budget that's inadequate is a transition claim that you will include in your transition process. But they need to understand the way to do that is put your professional forward. I will tell you, I have stood in front of unit owners so many times and beaten the shield for the board, taken the arrows, the bullets, so to speak, and said, this is what you want. If you want your lawn to look green, if you want the clubhouse to be properly managed, if you want to have a good management company, if you want things to run smoothly, you got to pay for it. And pardon the language here, it sucks that the budget that you were given was inadequate. You were told that it's going to cost you $100 a month to stay here and have all these services provided to you. It's now going to cost you $175, but that is life. That's the truth. And as the board, they're going to go back to the developer and try and get the developer to fund for those deficits in the past. But going forward, you have to pay for it. And if you want to live here and you bought into a home that's in a community, you got to pay for it. You got to pay what it's realistically going to cost to run this community. And that's the bottom line.
Yeah, again, reinforcing that, education is the key. If unit owners understand and are educated the process, the problems, and what's going on, then 99% of the time they're going to understand and they're going to go along with the recommendations to make sure it's a strong community, both financially and physically. I appreciate everybody staying.
There's one more question, Mitch.
Oh, who pays for the transition study? Usually new associations are operating in very limited funds. Unfortunately, typically the transition study is paid for by the association.
Yeah.
And it's very rare, like you say, that a developer will put in the initial budget the cost of doing a transition study. So that is a problem sometimes, but if you work with your professionals, speaking for Mohammed and me, even though he's not going to say it, if you said that we have a cash flow problem, we need to pay out the study over a period of time, most of the times the professionals will do that.
Yeah.
So don't be afraid to discuss with them those concerns, because we're all aware of it.
One of the things that, sorry to interrupt.
No, I got a minute.
Is working capital. You can utilize working capital because that's what it's available to you for.
Yeah, the other thing I want to mention is, there are a number of managers on this call that also do work for developers. Developers are not your enemy. Developers are, if we didn't have developers building associations, we all wouldn't be in a job.
Exactly.
Developers are our partners, and, a number of the managers on this call actually do work for developers, and hopefully out of this presentation, they are looking to you for guidance on how to go through the transition process in a non-confrontational way. So bring back to them your communities and share with them everything you've got today. That's kind of the objective, for you to understand and for you to bring that back to everybody. The other thing I'm going to mention is that I mentioned the best practices paper. We will send an email out to everybody and include on that a copy of this best practices paper on transition. Again, speaking for myself and the mayor, if anybody would like to have this presentation given in their management office, we'd be more than happy to do it. If you're within an hour driving distance, I gave a seminar the other morning in Harrisburg, Pennsylvania, and had to be there at 8 o'clock in the morning, so don't ask if you're out there. But if you're local and you'd like to have any kind of presentation in-house, we'd be happy to do it. Last thing I want to mention is that we give a lot of webinars, and upcoming on March 4th is how to request a proposal for engineering services. We get calls all the time from managers that want a proposal for engineering services, and they really don't know how to ask for it. So that's what that webinar is about. March 25th, we have on selecting the right contractors. April 15th, we have water everywhere. So we're scheduled out through December, And when we send you all a thank you for attending and the best practices paper, we'll also send you a copy of our webinar series for the coming year. If there's any topic we do not have, please feel free to ask. We'd be more than happy to give it. And thank you very much, everybody, for attending. Have a great day. And please remember what the password was to get continuing education units. It was rainy day, even though it looks like it stopped where we are. Were there any other questions? No? All right, well, thank you very much for joining us. We hope that was beneficial to you. And again, if you have any questions, please feel free to email us. Thank you, and have a great day.